Next, I want to introduce Adam Zayed, the managing partner from Zayed Law Offices in Joliet. He's been the managing partner since 2009. He's a trial lawyer concentrating in trucking, negligence, car accidents, and highway accidents. And he's tried cases throughout the state of Illinois, as well as in many other states throughout the country. He's here to talk about Armstead versus National Freight and collateral estoppel.
Thank you, Anita. My name is Adam Zayed. Yes, I've never handled a workers' compensation case, so thank you for having me. So the reason that I'm here is because I had a case that went up to the Supreme Court. As a prefatory, I've been in ITLA for 12 years. I was actually sworn in 12 years today, and so this is a great honor. Thank you all very much for having me, and I absolutely love ITLA, and it's wonderful to see my office here as well, the colleagues and lawyers from my firm. It's been wonderful experiencing the workers' compensation seminar, and so without further ado, Armstead versus National Freight. So this case was heard by the Supreme Court on September 15th, 2021, and this case is going to address a very interesting issue, and more specifically, the third district did something that I'm going to give some opinions about later, and I will give another prefatory, which is that any opinions here are exclusively my own, but I'm going to say what I think about what the third district did, and I'm really hoping that the Supreme Court sort of bails the good workers' compensation lawyers of Illinois out here. But anyways, the third district, they applied collateral estoppel to workers' compensation contracts. They said that these contracts are prior adjudications on the merits, and they explicitly said not only are Pennsylvania contracts, which is where the comp case underlying my third-party case was proceeding, but actually that Illinois work comp contracts are prior adjudications on the merits. So I wanted to tell you that I thought that this case was very, very important, and I wanted to make sure that it was handled as well as possible. The third district, what they did was they applied the tenets of Tallarico versus Dunlap, which is an equitable doctrine. And it's a case that is from 1997, and it was actually handled by, I think, maybe many of you know him, an appellate lawyer named Mike Rathsack. Now, if you know Mike, he's one of a kind, and he's a real advocate for people in the appellate level in the state of Illinois. Mike was happy enough to help me with this case, and I have to say that if we do come down with a win at the Supreme Court, it's in no small part due to the efforts of Mike Rathsack. But anyways, he argued this Tallarico versus Dunlap case, which is from 1997. And the basic principles of collateral estoppel are that, there's some other matter, there's a third party, there's some action, and that the courts are gonna apply this other action to a second action. And so the tenets are, the issue decided in the prior adjudication is identical. And usually it's like a criminal case or some kind of collateral judgment or some kind of consent judgment, and they're going to apply that. So the issue of identicality is not a big deal. However, the one that tends to be a big deal, if you ever dealt with collateral estoppel, is was there a final judgment on the merits in the prior adjudication? This is a big issue. I've had this come up when I'm dealing with some kind of case where my client committed some kind of criminal act, allegedly, and some defense attorney is trying to apply that to limit their third party. Well, it happened to me here where a defense attorney found a work comp contract in Pennsylvania and tried to apply that to my personal injury case. Anyhow, privity is the third component. Usually that's not a big issue because it's kind of the same party involved. But then unfairness is a big issue, and that's because this is an equitable doctrine. Unfairness. Collateral estoppel is supposed to be a doctrine of fairness. This gives the judges latitude to do things that are fair and right. You'll see that some of the things that the defense attorneys did in my case were not particularly fair, and the good judges in the third district rolled with that. So briefly, the facts of Armstead versus National Freight. I want to tell you a little bit so I can get through this. It arises out of a truck crash that happened in March 5th, 2015 in Grundy County. My client was sitting in a cab, sleeper cab, and another truck hit him, caused him to fall off his sleeper cab. And so what happened is he suffered a complex tear of his medial meniscus requiring surgery, and then some spine injuries requiring a fusion, and then subsequently a discectomy. I mean, these are real injuries. So his employer is this company, Mad Freddy Mushroom, out of Pennsylvania. I represented my client Clifton in his third-party case in Illinois, in Grundy County. And then there was another attorney in Pennsylvania that represented him for the comp case. I had nothing to do with the comp case. Clifton retained this lawyer before I was involved. And I will say there wasn't a lot of communication between me and this comp lawyer. Maybe that's something that should change. Anyhow, there was an IME in this work comp case, and the IME doc, God bless the guy, says it's a right knee strain only. Right knee strain only. So what happened was they offered him $110,000. Clifton knew that he had his shot with his third-party liability case. He's like, okay, I'm going to take this comp case. He takes the $110,000. They include some language in the release that I don't think anybody here would have included, but for some reason his comp lawyer in Pennsylvania, maybe given the vicissitudes of Pennsylvania law, included some very specific language. And state the nature of the injury, and it is right knee strain, period. The parties agree the claimant did not sustain any other injury or medical condition as a result of his work injury. Now, I don't like that language. I don't think any of you would like that language, but it was there. And I think that that's because the comp lawyer in Pennsylvania was relying on some very specific language in Pennsylvania contracts. And I think that, I've scoured the ITLA listservs. I look at them every day, maybe same as you. And in Illinois, my understanding, and you can correct me if I'm wrong, but we don't think work comp contracts are prior adjudications on the merits. They're just approved, And I think that, we'll deal with that and how the third district handled that a little later. But in this Pennsylvania work comp contract, there was some very specific language that Clifton was relying on and his lawyer in Pennsylvania was relying on. Clifton was very aware of this language. He's like, is this going to get in the way of my third-party case? His attorney says, no way. It looks big enough. So the highlighted part here says, agreement as referenced of record is appropriately approved and binding only on the signing parties. So that's step one. That is a limitation. It says that this agreement is binding only on Clifton and his employer. One would think if it's binding only on the parties, it doesn't apply to people beyond that. And then another big component here is it's limited to their respective rights and obligations under the Act. And then decision is entered without adoption or litigated determination on the merits and does not alter rights or obligations of any third party not a signatory to the agreement. Now that's a lot of language. One would think that would be sufficient. If there's some stupid language limiting the injury to right knee strain only, one would think this would serve as something of a cure-all. Or at least I would. That's a specific disclaimer. Not to the good lawyers at Johnson & Bell. So in my case, they sent a subpoena. And they got the Illinois workers' compensation contract. And I don't know, maybe some of you are along the lines of me. I'm like, okay, you got the work comp contract. What of it? Stop wasting my time. So the guy files a partial motion for summary judgment. And he's alleging all sorts of things that, should bar Clifton from making his claim, including that this was a judicial admission. It's not a judicial admission, but they make those arguments. That res judicata should apply and that collateral estoppel should apply. I thought this was a whole crock. I thought the judge was just going to throw it right out. It really did. But we argued hard. Right, Julian? All right. So the fact of the matter is the judge in Grundy County, he saw right through the baloney when it came to res judicata and collateral estoppel. But he was like, you know what? I think that this is a judicial admission. Now, am I frustrated when I can't get a good judge to make a good ruling? Yeah, but he says it's a judicial admission. And so I know it's not. It just isn't. Even the third district saw through that one. The judge, quote, said, this is giving me mental torsions. And it was really tearing him up. The decision took forever. He said it's a judicial admission. I filed a motion to reconsider. It was denied. So the third district looked at this issue of judicial admission, and we're thinking, okay, we're actually going to win here in the third district. This is great. And then you know what? We did. We won in the third district. They said it's not a judicial admission because it's not a judicial admission. And so their ruling says a statement cannot be considered a judicial admission when it is made in the course of another proceeding. All right, pretty definitive. I'm like, yes, we're doing great. And then, they did something that I have not seen before, and maybe a few of us will see successfully implemented in our careers, which is they filed, the good people at Johnson & Bell, a petition for rehearing. And so petitions for rehearing are granted like once in 7 blue moons or something. They're very rare. And so I put some GIFs here to give you the sense that I had. So that's Michael Corleone. He's not happy, Just when I thought it was out, they pulled me back in. And see, I'm trying to be multi-generational here. And so I also include a reference to the Lord of the Rings. That's the mythical creature, that Balrog, cracking his whip and taking Gandalf down into the depths of, where is that? Mines of Moria. And he's doing that. Why? Because they expected they'd be getting out. And I thought I was out. I thought the third district ruled in my favor. And they pulled me back in. So, the third district takes this petition for rehearing, and it's like a total shocker. They review it on the issues of collateral estoppel, something the trial judge, easily dismissed. And I'll say this is getting into the realm of my personal opinions, so I take the hits for this, but this opinion was conclusory, inelegant. It mischaracterized the purpose of the workers' compensation system, and it clearly disregarded the plain language of the contract. The good people at the third district on the issue of collateral estoppel, they made their mind up. They decided that work comp contracts in Illinois are adjudications on the merits, and they said, you know what, same thing with Pennsylvania. This is an adjudication on the merits. I'll go over some of the language, but the enigma to me was, we have this plain language. It's clear disclaimer, I'm bulletproof. Why are you messing with me? So I included this nice quote from Aldous Huxley. Facts do not cease to exist because they are ignored. They clearly ignored the facts of the plain language. Just in a basic format, and I'll get into it a little bit, third district more or less said that Clifton Armstead had incentive to fully litigate his case. And we can say that, I think we all disagree with that. We know workers' compensation is not a complete compensation system. We're trying to help these people. You're trying to help these people. And the average value of a workers' compensation case, it's not going to be, many millions. And sometimes the defense costs of these workers' compensation cases are more than what they end up paying out. These workers are incented to take this deal and to move on with their lives, and especially if they have a third-party case to get done with the work comp case and maybe move on with a third-party case. Or alternatively, I know that the system and the structure of workers' compensation case is set up to get workers a prompt result. And that's my understanding. You can tell me if I'm wrong. But we're supposed to get justice for these people in a prompt way and to do it efficiently. You guys agree, right? Yeah, so of course this man had an incentive to take the $110,000 rather than waiting for another 2 years. And then, in this particular case, he had the third-party case coming. He had an incentive to litigate, to settle it. And then they just totally decided that this was a prior adjudication on the merits. They decided Clifton is in privity, and then I'm going to show you a real nice quote where they just say, hey, you know what? The fact that we're barring Clifton from this potentially multi-million-dollar case for his complex medial meniscus tear and then also this fusion and this discectomy, there's no unfairness that Clifton is going to be suffering. They just say that. It's like, it's not unfair. End of opinion. So I want to show you some of the elements here. This is the third district's opinion, and they say, highlighted, the agreement entered in the workers' compensation proceedings set the parties' rights and liabilities based on the agreed facts stated in the agreement. Thus, it qualified as a judgment on the merits. And then In Illinois, a settlement award entered by the Workers' Compensation Commission is a final adjudication of all matters in dispute up until the time of the agreement. Now, I mean, in my opinion, that's an opinion. I think all of us would disagree with that. I think the question is, was this a not an understanding of how Illinois workers' compensation works, or was this a decision entered with intent? Is this judge trying to change things here? I mean, if this was promulgated, this would change things. Anyways, further down, despite this, plaintiff claims the language of the agreement precludes a finding that the agreement acted as a final adjudication on the merits. That's our argument, the plain language should preclude it. He says we disagree. That's because it conflates the terms litigation and prior adjudication. This judge is just making his mind up. He says it's a prior adjudication on the merits. So I'm in this spot. We have a bad decision in the 3rd District. What do? We file. We try to take it to the Supreme Court. And we're doing this to try to do something right. So further on here, plaintiff had both the incentive and the opportunity to litigate the full extent of his injuries. And then he kind of starts the judge starts laying into this, an independent medical examiner opined that the plaintiff suffered an injury to the right knee as a result of the March 6th incident. And then it makes sense that the plaintiff ultimately narrowed his workers' compensation claim. His failure to proceed with any additional injury claims acted as a concession on those issues. Now, it goes on further. We are not persuaded by plaintiff's argument that he agreed to settle his comp claim, limiting the extent of his injuries simply because he was out of work and needed money. It is true that the incentive to litigate might be absent where the amount at stake in the first litigation was insignificant, or if the failure in future litigation was not foreseeable. Plaintiff had every incentive to maximize the compensation he could obtain in the workers' compensation case. Okay. So I think that this is someone who's making an argument here, I think that the system is set up, and this is not consistent with the workers' compensation system in Illinois. Somebody here is advocating. I mean, it's kind of sad to see. And then in that conclusory sort of pat manner that I was describing earlier, on the issue of unfairness, one of the doctrines of collateral estoppel, it says we find no unfairness. So, it's like I'm making the opinion, hey, it's a prior adjudication on the merits, and, it's not unfair either. So I have a problem with that. And so we filed this petition for cert for the Supreme Court, and they actually took it. I mean, that's awesome. I mean, this is very rare, and it's an honor. And we have the able and brilliant Mike Rathsack, if anybody ever needs help with an appellate case. And I'm thinking that they took it for a reason. They're going to do something. And so some of this will delve into my personal prognostications about this. But anyways, I quote someone from the ITLA listservs here, and it's a quote that I think establishes how many of us think about these Illinois work comp contracts, which is that the parties sign underneath where the injuries are generally described, along with other specifics in the terms, and the arbitrator signs that he's reviewed and approved it. That's what they do in Pennsylvania too. And Illinois does not adopt or adjudicate anything. I mean, neither does Pennsylvania. And that's why as to Illinois contracts, this is a bad decision. It's also a bad decision as to Pennsylvania. So, I mean, I just sort of facetiously include this language again from the contract. It says, entered without adoption or litigation determined on the merits. And what is my client supposed to do here? So I'm thinking that if, for some reason, the Illinois Supreme Court took this case because they want to promulgate and disseminate the stuff that happened in the 3rd District, I mean, I think that that's an enigma. I think it's kind of like silly poppycock, but in that unlikely event, or potential event, I'm thinking that the way to combat that is coordination and synchronous litigation between workers' compensation lawyers and third-party lawyers. I think that for all of you who do third-party cases and comp cases, it's going to be easier for you to see the potential quagmires. And if you're handling a case and you're working with a third-party counsel as well, maybe it's good to communicate with them about what's happened with that third-party case. And then, kindly suggest refraining from including wildly restrictive language, like if a guy has a need for a fusion and a discectomy or brain injury or a complex medial meniscus tear, and you just say right knee strain, maybe don't do that. And then maybe include some language like the parties agree that plaintiff only, so anyways, include the language including like the following: the settlement agreement does not affect any rights that any party to this contract may have against any third party. The parties dispute the nature and extent of the injury to plaintiff's body part. The agreement does not preclude plaintiff from seeking recovery from any third party for any body part not listed. I mean, existentially, because they just threw out the plain disclaimers from the Pennsylvania case, part of me is like, okay, we include this stuff in work comp contracts. Are they still gonna, just disregard it because they say that it's a prior adjudication on the merits? I mean, we got to watch out for that. We got to see what this Supreme Court does with this line of cases. But I mean, more or less, I think pursuant to this case that one of my colleagues was able to find, language like this has been successfully included in settlement contracts in Illinois. Maybe many of you know better than me on this, but workers' compensations attorneys can include limitations. And then additionally, were language like that to be refused by an arbitrator or by somebody, or a defense attorney, a respondent's attorney, I think that one of the options is to seriously consider deferring resolution until you have certainty about what's going to happen with that third-party case. And I also suggest watching out for subpoenas from defense lawyers in third-party cases trying to get those work comp contracts. That being said, it is something that doesn't make any sense to me. Like, why would the Illinois Supreme Court take this case, and why would they want to promulgate that law? And I mean, in my experience, the Illinois Supreme Court only wants to take cases if they want to set something that's firm, something that's going to make some sense, something that's going to give guidance. And I think that one of the things that bugs me is that this third district case is so easily worked around. Okay, so they say it's a prior adjudication on the merits, then don't settle it. I mean, is that what the third district wants us all to do? To just delay all of our work comp cases? Is that what they're thinking? That seems like it undermines a lot of things. It increases the workload for workers' compensation arbitrators. It increases the workload for you. It delays justice for workers. Is that what they want? Maybe the third district just was trying to limit this decision to a particular set of facts, and they didn't see the broad scope. I mean, what's the deal? I think that the Supreme Court has something to say on this subject, and for these reasons, I am thinking and I'm hoping and prognosticating that they're going to come in with an opinion that says that this is something that is not a prior adjudication on the merits, and they're going to reverse and remand what happened in the third district. I mean, the Supreme Court is just too elegant to set up such a stupid set of scenarios where a whole swath of people, there are 30,000 comp cases filed a year, and anyone with a third-party case is now incented not to settle because the language might be a quagmire because of what the third district did. Why would the Supreme Court do that? So I'm hoping that we get a good ruling for the right reasons and follows the spirit of the law. And also I take some umbrage at the idea that application of this opinion from the third district creates this lopsided applicability situation where it just hurts the workers, and so the third-party defendants just have this wonderful boon. Hey, let me go subpoena this thing now. It's part of their work product. I think that's very silly. Why would they undermine the system in that way? I just don't see it happening. And so one thing I wanted to raise here is that the defense attorneys in that case of mine on appeal, they actually wanted to limit it to just Pennsylvania cases. I think that they saw a certain gleam in the justice's eyes, and they were like, this is just applicable to Pennsylvania, right? And I think that, that type of sophistry, I see that, and I see that they know what's going on here. And then also I think that I want to, kind of coming to the end here, but I just think that that particular opinion from the 3rd District is very silly, and I'm looking forward to the Supreme Court undermining or overturning it. And then one thing as a conclusory remark is that ITLA amicus curiae committee filed some briefs in support of this, and I wanted to say thank you for that, because that's a wonderful thing. And for a client like mine who for 5 years has been in the jetsam and flotsam of the system, to have that kind of support, it was meaningful and it was great. And there was a great quote in one of them. And the quote, this is one of the headlines from the brief, it says, "Express language disclaiming preclusive effect of a consent judgment's finding should be respected." Like, to that I say, yeah, true fact. So that's the end, and if anybody has any questions, feel free to reach out to me. My name's Adam Zayed. I work out of Joliet. Thank you.